Good afternoon. We want to welcome you to this presentation on immigration and employment options for graduate students, researchers, and postdocs, hosted by Notre Dame International and the International Student and Scholar Affairs Office. We're really pleased so many of you could join us, and we're particularly thankful for our speaker today, Tom Arkell, who will introduce himself shortly. I just wanted to do a few housekeeping notes, and that is that some of you submitted questions to the RSVP form, which we'll address at some point in the presentation. But if you have any additional questions, especially if a question comes up after Tom has explained something, we ask that you put that in the Q&A form. You should be able to see that at the bottom of your screen, and you can just submit your questions there. We are recording this presentation, and we will send it out to everyone at the end of the, by the end of the week next week. And it will be available for about a week after that for you to access once we've released it. So again, any questions, please feel free to submit them to the Q&A section. We expect that we'll be here together for about an hour. If there are any questions we don't get to, we'll definitely take notes and follow up with you if you submitted them. So again, Tom, such a pleasure to have you with us today. Thank you so much for taking the time to speak with our graduate students, researchers, and postdocs about their immigration and employment options after finishing their program at the university.
Thank you very much, Leah. Thank you also, Ali, both of you for setting this up and all your efforts. Hopefully the information I'm going to provide is helpful to those who are listening today. I was an international student myself at the University of Notre Dame. I was F1 student as an undergraduate, and then stayed there for law school and graduated also from Notre Dame Law School. So I went through the immigration process. That's how I became an immigration lawyer. I went through the process myself. I took immigration law at Notre Dame, and a lot of people think Canada doesn't count when it comes to international students, but I was, again, issued an I-20. I was stopped and questioned at the border when I traveled, as many international students have been. And it's kind of a tumultuous time right now for the international community, but hopefully the information I can provide will be helpful for you both to make you aware of a lot of the changes that have been occurring recently, and to provide you with some helpful information so that you have some options that you're able to navigate, which may help you gain future employment after you leave Notre Dame. Some of the updates that I'd like to provide to you, I'm going to give you a brief overview with recent updates, and then also going to go through, give you a general overview of the U.S. immigration system, and then the usual progression for students for employment is F1 status, then H-1B, and then permanent resident. I'll go through that and then give you some options where you're able to petition for yourself for permanent residence if you're qualified. One recent update is that there's a proposed rule with regard to students, instead of being admitted for duration of status, that students may be admitted, F1 students, for 4 years or 2 years for certain countries. There was a public comment through October 26th, and that may go into effect in the near future. Any questions related to F or J status, I would direct to ISSA. They're very knowledgeable people like Leah and Ali in that office who can advise you with regard to your F or J status. And if this proposed rule does become effective, I would direct questions there. As an international student or a postdoc or employee at Notre Dame, any issues related to F or J, you'd want to go to the international office. You don't need to pay a lawyer to get advice on an F or a J issue. And so if a lawyer is trying to have you pay them a lot of money to get advice on an F or J issue, you might be getting ripped off. Go to ISSA first to make sure to see if they can help you before you hire a lawyer for an F or J issue. There's going to be a significant increase in most filing fees for USJS, but there was litigation, so those are on hold right now. The prevailing wages, so a lot of individuals who are here in the United States are working in H-1B status, and many times those individuals will have their employer apply for permanent residence. Both for an H-1B and for a permanent resident, the employer has to pay a prevailing wage. Those wages went up significantly on October the 8th, so it would make it more difficult for an individual employee to be approved for an H-1B or permanent residence application filed by the employer. So part of what I'm going to talk to today are opportunities you may have to become a permanent resident and avoid these issues with the prevailing wage. That may change, if there's a new administration, which it looks like there may be, but obviously there's litigation there too. But I'll provide you with ways to potentially avoid these prevailing wage problems. Premium processing fees. So there's a way for an employer to file to get the H-1B approval expedited. That went up from $1,400 to $2,500. The good news is that there may be premium processing now allowed for NIW, which are national interest waiver petitions, which I will get into detail. And that's a way for qualified PhD students, postdoctoral research associates, to petition for your own green card without an employer and without the prevailing wage issues. The recent issues have come up with regard to there's people refer to them as a travel ban, but there was a travel ban with regard to certain countries, for example, Iran, where individuals were not permitted in most visa status except for possibly F or J, and there was a ban with regard to immigrant visas. There are now travel suspensions, so it's difficult for people to come in on an H-1B. There are executive orders set forth with regard to travel. So all of these things have made it a little bit more complicated. The general rule, I'd have to say right now, just as is to stay in the United States unless you absolutely need to travel, because there's no guarantee if you leave that you're going to get back in. Things should open up hopefully here soon with regard to travel suspensions and quarantines, and there's the Schengen countries where people have difficulty coming in. That should open up hopefully in the near future, but in the meantime, unless you absolutely have to travel, the best rule of thumb is probably not to travel. No deference for extensions. What does that mean? What that means is that people who are already here on an H-1B, if they file for an extension, it's not guaranteed that it's going to be approved in the past. If someone who was here on H-1B status, we filed for an extension, the probability is extremely high that the extension would get approved. Now, with the Buy American and Hire American initiative, it's become more challenging for extensions to be approved. Interviews for all permanent residence applications, in the past employment-based applications. So when an employer filed on your behalf, or you filed a self-petition for extraordinary ability or national interest waiver, you didn't have to go and be interviewed. Now you do have to go and be interviewed. So I'll talk a little bit about that and how to be prepared for that interview. And then public charge issues, that was less of an issue, but it's become more of an issue. And there was litigation just recently. The Seventh Circuit Court of Appeals, I think maybe yesterday, issued a decision. So there have been times where you've needed to file a new form. It's called a 9944. There have been times when you haven't. And so right now, as of today, which might change as of tomorrow, you do. But you need to show that you can support yourself or your family here, that you, if you've had any type of Medicaid, or you've had different types of government assistance, that needs to be set forth in your application and explained. You also need to provide credit scores and show that you are not going to be a burden on society. So it's a cumbersome form, but these are things that can be overcome. Oftentimes, though, people need help, more help now probably than ever before. As far as just a big picture overview of the U.S. immigration system, there's non-immigrant status, for example, F, J, H-1B, O-1, and it's alphabetical generally. So B1 visitors, F1 students, J1 research scholars, H-1B specialty occupations, O-1 extraordinary ability. That's non-immigrant status, the intent to come to the United States for a limited period of time. Permanent resident status, it's often referred to as your green card. And then once you've had your green card for 3 years, if you're married to a U.S. citizen, or 5 years, if it's based on employment, then you can apply for U.S. citizenship. And then once you're a U.S. citizen, obviously you can vote, and there are benefits from a tax perspective and other things. So that's the general kind of big picture overview. OPT, as many of you who are in F1 status know, that you are potentially eligible for up to 12 months of full-time OPT after you graduate. I'm not going to get into this too much because this is something you want to talk to the international office about. If you're in F1 status, you'll want to make sure that you talk to the international office about timing of your OPT to make sure that you apply in advance. So you increase the time you're on OPT and you decrease the time that you're unemployed, because you cannot accumulate more than 150 days of unemployment during the entire STEM OPT extended time. So you generally have 12 months of OPT, and then if you're in a STEM field, which you'll want to confirm with the international office, then you may be entitled to another 24 months of OPT. J1s, so there's some individuals who may come in as researchers on J status. If you are on an F, one thing you want to know is if you're going to go work for another employer in J status, that you may subject yourself to the 2-year home residence requirement. And what that means is that you cannot change your status from a J to an H, for example, or adjust your status from a J to a permanent resident unless you either go home for 2 years or you get a waiver of the 2-year home residence requirement. There are different ways to get waivers, which I won't get into today, but that's one thing you need to be aware of if an employer wants to move you from an F to a J, is that you may subject yourself to the 2-year home residence requirement. H-1B. H-1B, as I mentioned, is generally the path between an F1 or a J1 and permanent residence. And it's beneficial to many international students after they graduate and start to work for a U.S. employer, because it's generally good for 3 years. You can renew it for an additional 3-year period. And it's allows for, the last bullet point mentions dual intent, which means that you can have a green card application pending and still continue to travel in and out using a valid H-1B visa, and continue to work for your employer using your H-1B status, which is a benefit. So it has dual intent, whereas, for example, F and J do not. It's the H-1B is for a specialty occupation. That's important, that it's becoming more of an issue for H's, that you go to work for an employer that has specific job title, job duties that meet the definition of a specialty occupation. It's usually not much of an issue in higher education, but it can become more of an issue working for a private company. H-1B is employer specific. You can only work for the employer, file the H-1B petition on your behalf. It's location specific. You can only work in the location for which the H-1B approval was issued. So for example, if you get an H-1B for St. Joseph County, Indiana, and then you get moved to San Francisco, California, the employer would need to file an amended H-1B, because the prevailing wage is obviously much higher in San Francisco than it is in South Bend, Indiana. The H-1B is also job specific. So if you're working as a researcher and then the company wants to move you into a managerial position, the company would need to file an H-1B amendment for the new position. When I say the company or any employer would need to file an amended H-1B petition. What is a specialty occupation? So the detailed explanation is in the top bullet point, but generally speaking, the more technical the position, the higher the probability of success it's going to be approved under the H-1B categories. So professors, accountants, engineers, architects, physicists, chemists, hard sciences are more likely to be approved under the H-1B, and in the business field, probably finance and accounting generally have a higher probability of success than marketing or management. Job titles, job descriptions are very important. The reason I say that is because if you're going to work for a large company, they're very well versed in job titles and job descriptions. I do a lot of work with different universities, Notre Dame being one of them, and also do a lot of work with research parks, IT companies, startup companies that are funded by venture capital. Some of these companies don't have a large HR department or have an HR department of one. So it's very important for you as a prospective employee to educate yourself about the immigration process and to know that the job titles and job descriptions are very important in terms of the degree that's required and the minimum requirements for the position. Prevailing wage, I touched on this earlier. The prevailing wages have gone up significantly, unfortunately, in some respects to a point where an employer may not be able to pay the prevailing wage as determined by the U.S. Department of Labor. This is where the job duties and titles and minimum requirements are important, because if a job title is something that is not, if it just says manager, for example, that's a pretty vague, generic title. Whereas if an employer uses manager when really you're going to be a chemist, it should say chemist. If the minimum requirement is a PhD and no experience, then that's what needs to be stated instead of that they would prefer a PhD and 5 years of experience, because a preference is looked upon as a requirement by the Department of Labor. So very important that the job duties and requirements are specific for the position, and they're not inflated, because that's going to end up with a high prevailing wage that the employer likely will not be able to pay. The employer also has to pay the actual wage in addition to the prevailing wage, which is paid to other employees in the same position with similar qualifications and experience. So if you're going in as an entry-level chemist, then the employer would need to pay you what they're paying other entry-level chemists. How much does it cost? This is how much it costs for an employer to file an H-1B petition. Generally for an H-1B, it takes it's saying about 6 months. I have been coming to Notre Dame to give presentations in person probably for about 20 years. I think this might be my first Zoom presentation to Notre Dame, but since they've implemented premium processing, they keep increasing the fees. There's a typo there. It's actually $2,500. We just changed that just before the presentation because it just changed, but it was $1,440. It's now $2,500. And the premium processing, USCIS will issue a decision much faster. I like to joke that many countries, you pay the government more money to do something faster. They often call it bribery. In the U.S., I guess we look at it as premium processing. But if you do pay, if the employer does pay the extra $2,500, then there's a number you can call, email you can contact, where you'll get more responsive service. But generally, if you're going to work for a private company, you shouldn't need to pay for the premium processing, and your employer shouldn't have to pay for it. And the reason for that is because there's a cap on H-1Bs and specific time periods. So if you're going to work for a private company, there is a cap on the H-1Bs that are allotted every fiscal year. 65,000 allowed for beneficiaries with a bachelor's degree and an additional 25,000 for beneficiaries who obtain a master's degree or higher from a U.S. institution. So if you have a master's degree or a PhD from a U.S. institution of higher education, then you have a higher probability of getting selected in the lottery, and there is a lottery. So with the lottery, in the past, there were FedEx, UPS trucks that were lined up beginning April 1st of each year, because the first day you could file was April 1st for the October 1 start date, which is the new fiscal year. But it has changed recently so that now there's a registration process where employers can register in March, and then there's the lottery. And then if you are selected, then the petition can be filed on April 1st. This is for the lottery, and the timing of the April 1, October 1 is for entities that are not exempt from the H-1B cap. So one thing that could help you in your job search is if you're moving into or you want to stay in academia, then institutions of higher education are exempt from the H-1B cap. So those H-1B petitions can be filed at any time during the year, which can be very helpful. The additional thing is if you're working for either a private company or U.S. institution of higher education, if you already have an H-1B and it's good for 3 years and it's extended, then you're not subject to the cap. If you're working for a private company and there's an amendment, you go from a chemist to a manager, then that amendment is not subject to the cap. I'm sorry, and that if you're going to work from a private company, and you're working at a private company and the company files an amendment from a chemist to a manager, then that amendment is not subject to the cap. If you're going to change employers, so you're working from company A as a chemist and you get a better offer from company B, and company B files an H-1B for you, since you've already been counted against the cap, the H-1B petition filed by company B is not subject to the cap. H-1B cap, I will just touch on this briefly, but generally if you're on F1 OPT and it expires before October 1st and the H-1B is filed by the company and selected, and your H-1B starts October 1st, but your OPT expires before October 1st, you can still work between the time that your OPT expires and the time that your H-1B starts on October 1st. Visa and an I-94, I'm going to touch on that briefly. So the visa, this is the stamp you get in your passport, as many of you know, when you come into the United States. This allows you to get into the US, but it doesn't necessarily allow you to stay here. So just because the expiration date on your visa is in the future, doesn't mean you can stay here for that entire time. What's the most important to know is that when you're allowed to enter each time, you're issued an I-94, and on that I-94 shows the date you're authorized to stay in the United States. Each time you come into the US, you want to make sure that that's accurate. If it's not accurate, then you need to contact ISSA and make sure that it gets corrected. This comes up, I see this a lot, both when an individual is in a situation where maybe there's been a termination. I had that happen for an individual who worked at Notre Dame and was part of this presentation. They were terminated and contacted me and asked me about, saying, well, their visa is for an extended period of time, but well, just because your visa is valid, once you're terminated, you may have a grace period, but after that period of time, then you will need to depart. We also see it when we're applying for permanent residence, and that when somebody's filing to adjust their status, they may be on an H-1B, but the person who reviewed their documentation at the border in error, admitted them in B1 visitor status. And so their status, unbeknownst to the person who came in, they were admitted as a visitor. It may have expired several months ago. They're I-94. And if you're out of status for more than 180 days, you're barred from reentering for 3 years. If you're out of status for more than 365 days, you're barred from reentering for 10 years. So make sure you check your I-94, and if it's wrong, please talk to ISSA to help get it corrected. With the H-1B cap, sometimes, or the prevailing wage issues, there may be other options for employers. If you're Canadian or Mexican citizen, the TN may be a viable option. If you can't find a job you want in your home country, or you can't find a job in the United States that you want, you may be able to go to your home country to work for an employer for a year and transfer in as an L1 intercompany transferee. If you are here in the United States and you're able to obtain high-level training that you can't obtain in your home country, you may be eligible for the HC trainee visa, which I've used successfully for some startup companies that provide extremely technical training. If you have a large number of publications, citations, service as a reviewer, you may qualify under the O1 extraordinary ability category. If you were born in Chile or Singapore, you may be eligible for the H-1B one, which is similar to the H-1B, but does not have the same cap issue. Or if you are an Australian citizen, you may be eligible for the E3 visa, which again, similar to the H-1B, but does not have the cap issue. Permanent residence, green cards, there are ways you can get permanent residence through your family member, and generally the closer the familial relationship, the faster you can get your permanent residence. So if you're married to a U.S. citizen, or you are a U.S. citizen and you want to file for a parent, for example, then you're an immediate relative and it's much faster. So there are options sometimes for family-based, employment-based. Sometimes people have to go through labor certification, where the employer has to re-advertise the position and show there are either no qualified U.S. workers. For people who are not working in teaching positions, or after the position has been published or been advertised nationally, that a university finds that you're the most qualified applicant for the position if you're a teaching position. So labor certification is becoming more difficult, primarily with the prevailing wages. And so there are ways that you can go directly to be the I-140 petition for alien worker under the national interest waiver or extraordinary ability. And then for people who are not born in China or India, you may be able to file the I-45 at the same time. So if you can file the I-140 and the I-45 at the same time, you may be able to get a temporary work card and travel document in 3 to 6 months, and your green card within a year without having to go through labor certification. As far as self-petitioning, again, it's a way to avoid labor certification. These are the 3 primary ways to do it. National interest waiver, if you're doing work that's in the national interest, extraordinary ability, if you're one of the best in the world at what you do, or investments, if you maybe don't qualify under some other category, but you have a significant amount of money to invest either into a regional center or to start a new business in the United States. I'm going to focus primarily on the national interest waiver because this is something that my office files a lot of. So there's myself, we have a team of people that I work with. She's helping me here, social distancing, but immigration practice manager, Stacy Rankenberg. She worked at Caterpillar for over a decade, and with me for over a decade, working exclusively on immigration. There's Jim Arkell, who's an attorney here, was a professor and worked abroad internationally, and exclusively focuses on national interest waivers, and many other people who we work with, paralegals. There's a team, I think, of about 15 of us together who are working exclusively on immigration. But in doing this and filing thousands of them over the last several years, if you're a qualified PhD student or a postdoc, then you may be able to go directly to the green card without having an employer go through labor certification and having the issues with the prevailing wage. There's a website, nationalinterestwaivers.com, that you can go to. We have an FAQ section and testimonials. So the NIW is a very good option for researchers, scientists, qualified PhD students, and postdocs. We're in the process of updating our website and putting noteworthy approvals and approval notices up there. I guess the good news is we've been too busy to do that recently, but it's something that the website where you can look at it and get some hopefully information that's helpful for you. These are the three criteria. There's a case, it's called Matter of Danisar. So the proposed endeavor has to have substantial merit and has to have national importance. It needs to be in the national interest. That's usually not an issue. The petitioner, or you as the scientist, researcher, postdoc, PhD student, have to be well positioned to advance the proposed endeavor. What that generally means is that they want to look at your credentials, what you're doing, your publications, citations, again, service as a reviewer, if you're an entrepreneur in a business setting, if you have patents, if venture capital funding is, or venture capital funds have funded your research because there's a significant commercial value there. Those are things that they look at to say, okay, what are you going to bring to the United States? And on balance, would it be beneficial to waive the labor certification? So what is your plan in the future? So what are you going to be? Are you going to continue to be conducting research in physics, chemistry? Is it going to be specific to COVID, to cancer, to AIDS, to some other type of significant problem that the U.S. is facing? And generally, at an institution of higher education like Notre Dame, these three criteria can be met. People want to know, these are questions that I get all the time. I also have a list of questions that I've received before starting today, and we'll also answer some other questions that have been coming in during it. But these are questions I often get for how many citations do I need to qualify under the National Interest Waiver category? Well, there's no magic number. I've had cases approved where people have no citations if the work that they're generating has received if they've received a significant grant, significant funding from a VC, if they have a patent, if they are working in something that's really compelling, if maybe they're working on a brand new publication that might be coming out in Nature, something that hasn't come out yet, but there are people who will be writing strong letters of recommendation. And I know it may seem for some people that they don't think they could ever get a letter from a Nobel Prize winner, but we have filed letters from Nobel Prize winners in support of different individuals throughout the years. So if you are working on something, and sometimes it may be protected because it's confidential, and it may be something that you're working on for the government, or through a PI for the government, or that it's confidential and proprietary. So if you're a researcher, we would like to see probably 10 independent citations, but we've had many approved just recently, 5, 7, 9, 11, 15. So it just depends on how strong your case is. What else do they consider? As I mentioned, I've already discussed that, I guess, in pretty much significant detail. How many letters of recommendation do you need? We usually like to file 4 to 6. Independent letters where people you don't work with are often given more weight than people that you do work with. Do we help with recommendation letters? Yes, we do. Is a job offer required for an NIW petition? It's not required. We get cases approved regularly for qualified PhD students, but it's definitely helpful to show that after you graduate that you have a job offer or that you're currently employed and that you're going to continue to be employed. Can you apply for F1 OPT status? Yes, you can. Whether you should or not depends on your qualifications. So how do we evaluate, or how do you evaluate whether you're qualified? We provide a free initial consultation where you can send your CV and Google Scholar profile to the email address at the bottom, stacy@dunlaw.com. We'll look at your credentials and give you an honest evaluation if we think that you may have a good case, or if you should maybe wait until your qualifications are more significant before filing the application. It's just as it's in your best interest to get your green card the first time you file it, we also want to make sure that we get your case approved. How much does it cost? I received a couple of questions about this. So these are the attorney's fees that we charge, $3,900, and we offer a payment plan because I was, as I mentioned, an international student at Notre Dame and a law student there at Notre Dame. So, and I didn't have a lot of money as a student, so I realized that this is expensive. So we offer payment plans, and we offer people to pay by credit card without charging them any additional fees to try and help out financially. The USCIS filing fee right now for an NIW is currently $700. The good news is that there may be premium processing soon, which I believe is going to be $2,500. And instead of getting an answer in about 6 months, you probably get an answer within 15 days. So that's a significant positive development for NIWs. Extraordinary ability, it's another way to apply without employer sponsorship, but generally I counsel people that unless you are from China or India, there's usually not much need to file under extraordinary ability because at the end of the day, they're not handing out platinum green cards. You just need to get your green card. And I generally follow the rule of file under the category that's going to give you the highest probability of success. And for most people, that's the national interest waiver category as opposed to extraordinary ability. We do file many extraordinary ability petitions if somebody maybe meets the criteria more clearly for extraordinary ability as opposed to national interest waiver. But there's a very high threshold for extraordinary ability. These are the criteria. You have to meet at least 3 of them. But even if you meet at least 3 of these criteria, major prizes or awards, published material about you, that you've judged the work of others, that you have a leading or critical role in an organization, that you have a high salary, that your research is original and of major significance to the field. So 3 of these criteria need to be met, but even if 3 of them are met for permanent residence, then there's a final merits determination that needs to be met where the officer has more discretion as to whether or not your case should be approved. And that's become more of a challenge within the last few years because some officers are not, in my opinion, maybe exercising their discretion in compliance with the regulations. So the extraordinary abilities become more challenging. We're still getting qualified cases approved, but it's just become more challenging. So the national interest waiver is generally a far better option for most people. I did, however, get a question from somebody who has over 100,000 or over 1,000 citations and 22 publications, which I'll get to. So people like that may qualify, but many people are going to have a tough time being approved under extraordinary ability. I-45 is the last stage of the green card process. It's filed for each individual who was not born in the United States. It can be filed at the same time as the I-140 for people generally who are not born in China or India, and if their priority date is current. Whether the I-140 and 485 should be filed concurrently, again, it comes down to your credentials and maybe if you're under time constraints as far as your status expiring. But if you do need a work card or a travel document, you can file the I-140 and I-45 concurrently at the same time. Usually get your work card and travel document in about 3 to 6 months and your green card in about a year. At the I-45, there's a background check, a medical exam, and then you're going to have to be interviewed at the end. And at that point in time, they're going to be questioning you about your background, if you were a member of any particular political parties, groups, organizations, received any type of public assistance. Things like that are going to be, or if you committed any crimes or been arrested, cited, or detained, these things will come up at your interview. So probably more at this point in time than I've seen in the last 20 plus years I've been practicing law, is when people probably need legal help with these types of applications. As far as questions, I have some questions here, and it looks like several of them have also come in. The first question that I have is, what are the benefits of applying for permanent residence for STEM degree holders, and what is the timing and cost? So what are the benefits for STEM degree holders of applying for permanent residence? As I discussed, that for an H-1B, the employer controls that process. The employer's perspective and your perspective sometimes are different. So sometimes an employer knows that once you get your green card, you're a free agent and you can go where you want. And so sometimes the employer is not in a hurry to apply for your green card, where if you say file under the national interest waiver category, you control your own destiny in terms of when you file and the green card process. That's one of the benefits of being in a STEM field. I did get a question, which I'll kind of morph into this answer too, as far as the humanities. It's more challenging to get approved under the humanities for a national interest waiver. We have had some approved, but it's definitely usually a little bit more challenging. But by filing a self-petition, you have more control over it as opposed to the employer, and you don't have the prevailing wage issue that you have no control over. That the employer has to pay at or above the prevailing wage, both for the H-1B and labor certification. So that's one of the benefits. How much does it cost? We talked about that. $3,900, $700 for the filing fee, $2,500 for premium processing. Do we help people who apply based on marriage? Yes, we do. We see a lot of international students who will meet somebody, fall in love, and apply for a green card. That happens a lot. And so, yes, we do help with that. If somebody said they have over 1,000 citations, 22 publications, they are subject to the 2-year home residence requirements. So the I-140 could be filed, possibly since this person's from India, under extraordinary ability, but you cannot file the adjustment of status until you get the waiver of the 2-year rule or you go home for 2 years. You see some of the ones that have come up just recently.
Yeah, Tom, I can do a couple of them. I've pushed a few and they answered. One is a student asked about how different is the H-1B to green card process versus the TN to green card process.
So the H-1B to TN, the H-1B has dual intent, the TN does not. So if you're on a TN, a Canadian or Mexican, and you've filed to adjust your status, you're going to have some travel restrictions after you file it. You'd probably need to wait until you got your advance parole or travel document before leaving the country.
The next question is, and there's actually a couple of questions about how to figure out the prevailing wage requirement for a particular position. Is there a website or some resource that students could go to see what that prevailing wage might be for a position they're looking at?
It's something that they can go, there's an OES wage database that people can look at, but it's very technical. So candidly, it's something that they should rely upon their employer for, or their employer's attorney. Because in the end, it doesn't matter what the student selects or the potential employee, it matters what the employer or the Department of Labor selects. So that's something that the prospective employee has no control over.
That's good to know. Another question is the definition of specialty occupation the same under the new proposed H-1B regs? You may have mentioned this in one of the lists. And does the new H-1B regulation affect academic H-1Bs at all?
So the new regulation, it's going to be more challenging generally. I'll just, in broad terms, specialty occupation has already become more challenging to overcome. It's going to become even more challenging, but the new regulations primarily affect, I would say, affect private companies and the IT industry more than academia.
Okay.
There's another question here. Can a PhD student apply for NIW during the PhD study? The answer to that is yes. They can. Whether they should or not depends on whether they're well qualified. And again, if they send in their CV, Google Scholar, we can let them know if it makes any sense for them to change to file it now. And a lot of that depends on when their status expire, what other options they may have, and the probability of success. We don't want people to waste their money. So if it doesn't make sense, we'll tell them it doesn't make sense. But is it possible? Yes, it is. And we do it all the time. And it's helpful if people get their green card before they graduate, because when they interview, then when the questions come up, are you legally authorized to work in the United States? Because that's one of the questions I have. If they have their green card, the answer is yes. If they have their EAD, the answer is yes. Do they need sponsorship? The answer is no if they have their EAD and or their green card. Another question, can J1 holders apply for EB1 or NIW once they've applied for the 2-year residence requirements? So a J1 holder can apply for an EB1 or NIW even before they've applied for a waiver of the 2-year rule. Whether they should or not depends on the probability of success of that waiver. So they definitely can apply once for the NIW or EB1 once they've applied for a waiver of the 2-year rule. Whether they should apply before or during or wait till after depends on the probability of success. But we've had many clients recently, we've been applying for either before they've even applied for the waiver because they know the probability of success is high based on the country they're from, and maybe they're getting a no objection statement. And they don't want to wait to get their green card. So they don't want to waste that time waiting for waivers, because waivers of the 2-year rule are taking a long time right now. How long will it take for NIW to be approved in general? We've been getting most approvals in about 6 months. With premium processing, it would cost more money, but we may be able to get an answer within 15 days.
There's a question about, I know we talked about this for business students before we started, but there's a student who's asking, do those with JD degrees qualify for an NIW, or is that like the business conversation maybe a little more difficult?
No offense to I guess my fellow JDs, but generally most people with a JD probably wouldn't qualify under the national interest waiver, because lawyers aren't necessarily working on scientific research that's going to have a significant impact on the national interest of the United States. So I think it's unlikely that somebody with a JD would be approved under the NIW category, although they might be doing something that's very compelling, say it's substantial human rights work or something. But I've been hired by law firms to get green cards for lawyers through labor certification. So there's other ways to do it as well.
There was somebody who asked just any suggestions or good questions or talking points to push back on recruiters who may not be as familiar with some of these policies and these options or opportunities that might be helpful for someone who's talking with a recruiter.
Well, I guess the thing that I would say probably more than anything is for international students to use your office and be proactive in applying for OPT as quickly as they can, to get their OPT as quickly as they can, within the constraints of the rules and regulations and the timing. But if they go to the interview and they have their OPT, they don't need they have authorization to work, right? And so that's one of the keys. Or if they can get their EAD through an NIW and adjustment, they have that authorization. If an employer isn't willing to hire somebody on an H-1B, it's going to be challenging to overcome that. So what they may be, if it's an international company, say, well, I'm willing to go work in my home country for a year, and maybe would you consider bringing me in as an L1, for example? The question, can you also talk about NIW for a PhD student born in India? Given the waiting time, what would be your suggestions? So if you're from India, the NIW is still a good option, even though that there's a waiting time before you can file the adjustment of status, partly because if, for example, you're on an H-1B and you get an approved I-140 for an NIW, your spouse in H-4 status, he or she could work, the H-4 spouse could apply and get the EAD and work. And also you establish a priority date. So let's say at the current time you have maybe 80 citations, and then you publish a high impact factor publication in Cell or Nature or something, and your publications, or you have several publications, you get over 1,000 citations, then you could file under the EB1 category for extraordinary ability, use your other priority date from your NIW and jump your place in line. That may save you a couple of years. And we've been seeing things like that a lot recently in October, when priority dates for India and China moved significantly, and we were able to file a lot of adjustment of status for clients from India and China. Is a professor position in humanities at an academic institution eligible for TN status? Possibly. It depends on whether or not the institution of higher education you're going to work for would hire you in TN status. They may hire you in TN status for a instructor or lecturer position. It may be less of a viable option for an institution of higher education and tenure track position, but that would be up to the university. But that's a good option right now, possibly a TN, because there's no prevailing wage problem. If one gets a tenure track job in a U.S. university, are there any disadvantages of getting EB1 visa instead of H-1B? Generally, if you get a tenure track job, and the reason I say this is because I represent a large number of institutions of higher education, and including University of Illinois, and I've done work for almost every state university in Illinois, as well as many privates. But most of the time, the university is going to file an H-1B for you, F1 or J1 to H-1B, because that shows the university that you have authorization to work for the university that filed the petition for you. As far as an EB1, if you file that before you get there and have your green cards, if you're very well qualified, then the university won't need to file an H-1B. If you're qualified, whether or not you file an EB1, if it's an outstanding professor or researcher, you need the university to petition on your behalf. EB1A, you may be able to do that on your own, but you probably also have to pay for that on your own. For marriage-based green card application, does your office provide an initial screen? If so, what kind of documents should we provide for that? So I would say if the person identifies themselves as having been on this Zoom call, we'll provide an initial screen for them to let them know if we think they have a legitimate case. So they just have to receive the person's name. So for this purposes, yes, we would. And that person could email Stacy@dunlaw.com for the initial screen. Can you apply for EB1 with a tenure track job from a small liberal arts university? Can someone work with an EB1 spouse visa? So can you apply for EB1 with a tenure track job from a small liberal arts university? Yes, you can, because I represent a number of small liberal arts universities. But whether you qualify or not depends on your credentials. And but if you apply for a green card and you apply for adjustment of status, then your spouse is also able to get a green card, which is, again, one of the benefits of filing the NIW adjustment of status, because then your dependent, your spouse or child or children can also get a temporary work card and travel document, which will allow your spouse and children to work. It looks like we're close to out of time. So
yeah. And it looks like you got most of the questions, so that's great.
Okay.
Well done. We can follow up on any of the
Sure. And we're happy to help out in any way that we can, especially during what's been going on, not only from the health situation, but from an immigration perspective. We know it's a challenging time, and if we can help any PhD students or postdocs at Notre Dame alleviate some of their immigration concerns or tensions, we're happy to do that. And so if we didn't answer any questions, we're happy to do that. Or if people want us to take a look at their CV at Google Scholar, just send it to stacy@dunlaw.com, and we're happy to look at that and evaluate it for no cost.
Great. Thank you so much for your time.
All right. Thanks again, Leah. Thanks, Ali. And thank you everyone who participated.
Yes. Such a pleasure. We'll be sure to send out this recording and the information within the week. And you feel free to email us at issa@nd.edu if you have any follow-up questions, especially pertaining to your FRJ status. Hope you have a wonderful evening, and we look forward to connecting again soon.
All right. Thank you very much.